a legal development till 2010 and 2020. They served as a basis for improving the legal system and deepening in the most important spheres of public relation. The key outcome of its implementation is very deep modernization of the national legislation. Constitutional reform of 2017 by initiative of Elbasy was new legal phase of further improvement of legal infrastructure. It was democratic mobilization of the presidential form of governance. The role of and independence of parliament was strengthened, and more powers were given to the government. Therefore, formation and development of legal system was a dynamic process taking into account international law and national traditions of building an independent state. We are continuing our work on empowering constitutionalism to ensure continuity of the rule of law. We are developing new concepts of the legal policy till 2030. One of the vivid achievements of independence is the Constitutional Council foundation and establishment. The legal positions identified the general approaches of the legal regulation of many institutions, which further became a basis for the development of the sector legislation. And it played a significant role in implementation of the principles and norms of the major law. This experience is a good base to expand the constitutional framework for the legal content. Dear participants of the roundtable, we are meeting in the eve of the upcoming of a big celebration. Years showed that the decision of the first president, Mr. Nursultan Nazarbayev, about moving the capital was a very brave and a right decision to make. The new capital opened new heights, opened the potential and capacity of the country. Using this opportunity, I would like to congratulate all citizens of Kazakhstan and architecture of our state and of our capital. I would like to congratulate Elbasy, Mr. Nursultan Nazarbayev, with the upcoming celebrations. I would like to wish you to stay healthy, to stay safe, and prosperity. Thank you very much for your attention. Have a fruitful and productive meeting. Can you pass our gratitude to Mr. Kairat for his very warm words and for his very deep and informative speech? Actually, it's not even welcoming remarks, I would say. It was a very profound overview. Mr. Kairat mentioned constitutional reforms, in particular reforms of 2017, and the legal experts in Kazakhstan, and not only in Kazakhstan, know that our legal system is currently includes a very interesting institute, particularly for us, for legal experts, for legal specialists, such interesting element as the law of the AIFC. And on behalf of co-organizers, International Financial Center is one of the organizers, and this is Mr. Kairat Kelimbetov, governor of the Astana International Financial Center, and also he is the chairman of the Agency of Strategic Planning and Reforms of the Republic of Kazakhstan. So these novelties, these breakthrough projects, which are currently serve as the basis of the activities of AFC, I believe will be developing also in our country overall and replicated multiple times and scaled up, as at least as I hope. Mr. Kilimbetov, the floor is yours. Thank you very much. Mr. Igor, for me it's a big honor to participate in this conference, to provide welcome remarks, as particularly in the eve of celebration of the Capital Days. This is also a year of 30th anniversary of our independence, and this is a great time to draw some conclusions, to look at our history and at our path. I would like to talk about the AEFC history. I would like to mention that in 2015, Elbası announced about the initiative about creation of the International Financial Center in Astana, based on the principles and standards and norms of the common law. It was a very brave initiative at that time, and it was announced in the context of reforms which are very well known as the National Plan, 100 steps and 5 institutional reforms. The Plan of Nation is a response of Kazakhstan to the global financial crisis, also to the crisis of 2014-15 with the decreasing prices on natural resources. We needed such infrastructure in the financial, legal, and investment state to attract investors. As it's known, foreign investors appreciate something they know, something they are used to. Therefore, we use the standards which are very common in leading financial centers, London, Hong Kong, Singapore, Dubai, and the model financial center, which was created not so long ago, was Dubai International Financial Center. Very actively we looked at this experience, and I would like to remind that Mr. Mami also worked as chairman of the Supreme Court, and Mr. Rogov was chairman of the Constitutional Council, and we had quite active discussions. How can we make such a possibility to create such an island based on the common law, where the bigger practice in Kazakhstan not is based on common law. And in 2015, as we already mentioned, amendments to Constitution, which took place in 2017, and the positions of government and parliament were significantly strengthened. Part of the reform was amendments where the provisions about capital, about Astana says about that there is possible to create, in line with the constitutional statute, a new provisions for another legislation. It was also part of the 100 concrete steps about creating International Arbitration Center, step 71, 75, about developing strategy, about creating international center based on the common law. Constitutional statute very deeply provides provisions both about regulator, about AFC, about AAC, about administration. And in July of 2017, there was official presentation and official launch. The financial AFC started its official operation with the participation of the Elbası and also leading financial companies with different governments. And just recently, we reported about the results of the first 3 years, which we are currently at. We also had a working visit from Elbası in June, and also we had a council meeting. We reported to Mr. Tokayev, who is the head of the council of the AFC, that within that time we've attracted about 4.5 billion in investment through the AFC platform. Also, we've registered more than 800 companies. If we speak about that, by 2025, we had 10 billion in investment and about 2,000 companies. We can say that the work of the International Financial Center during that time was quite efficient. I would also like to remind that there were a lot of discussions how the convergence will be about the European law and common law. There were different conferences dedicated to this topic. Extra Finance Day discussed quite extensively. I am really glad to see Mr. Michael Blair, who published a book about the AFC legal system, being the person who is well aware of the actual situation, how we came up with these ideas. I think during the panel session he will share his experience and perspective. Another big direction where we attracted a lot of experts. We looked at the court, experience in Dubai, in Hong Kong, and our court. First of all, by the Lord Wolf was the first president of the court who was leading the reform in the United Kingdom, and now Lord Mons is another leading judge in common law, and Mr. Christoffel, the registrar, will be sharing more details about that. Overall, I would like to say that AFC, as a very brave initiative and even a very important geopolitical decision, is already contributing a lot into the economic development of Kazakhstan. And I would also like to remind you that when the decision was made that this decision won't be viable without amendments to constitution. Actually, the first president, Elbасы Nursultan Nazarbayev, put all the dots on i's, and we very much appreciate his bravery, his will, because he was initiator of many developments, and as economic achievement, when we say that economic comes first, during that period proved to be right, and Kazakhstan is rightly taking very good position among CIS with economic social development positions, and reform about the AFC will be another good contribution to the further sustainable development of Kazakhstan. Thank you very much for your attention. I would like to wish a fruitful discussion to all the participants. Thank you very much, Mr. Kelimbetov. During your speech, I remembered one episode. About 10 years ago, in 2011, as far as I remember, after the constitutional reform, we reported at the Venice Commission about the ongoing work. I was approached by a colleague from post-Soviet countries. He said, why what we are suggesting is not being approved, and what your Mr. Nazarbayev suggests is always supported. I said, oh, well, my condolences to you. But, after amendments to the Constitution in 2017, and when, thanks to these amendments, we were able to establish AFC, the situation actually replicated itself. Before that, the Venice Commission, 3 or 4 years before that, for one country did not support similar suggestions about creating a center with common law. And for our amendments to Constitution touching upon the same things, basically, nobody commented, and the Venice Commission very tightly follow our achievements and our work. And authority of our leader plays a key role here. His suggestions are always quite attentively attended to and are considered by the international community. Colleagues, when we are speaking about legal system, of course, the central role in forming and developing this system and ensuring its proper functioning is ensured by the Ministry of Justice. And today we have Minister of Justice of the Republic of Kazakhstan with us, Mr. Beketayev, who would also like to provide the welcoming remarks to the participants of the roundtable. Mr. Beketayev, please, the floor is yours. Thank you very much. Mr. Igor, dear participants of the roundtable and dear guests, I would also like to welcome you at this event. I would also like to thank organizers. Kazakhstan is a politically stable state with dynamically developing economics. As a legal state, continues its international commitments and implements leading international standards. I believe that today's event will become an efficient platform to discuss issues of legal nature. I'm sure that the recommendations approved will positively affect in ensuring rights and freedoms and in protecting interests of our citizens. I would like to wish the participants of this event interesting discussions and good outputs in terms of recommendations. Thank you very much. Thank you very much, Mr. Beketayev. Yes, the legal system is evolving on research and science-based work conducted by the Ministry of Justice. Not so long ago, actually, starting from today is the first day, I believe, we have new administrative procedural code, which is a revolutionary step in ensuring rights and freedoms of our citizens. I would like to wish you the best of luck, Mr. Beketayev, to you and your ministry in implementing ideas you were able to implement in the draft and already in the enacted law. On this part, we are concluding our opening part of the forum, and I would like to provide the floor to as our first speaker, to Mr. Viktor Malinovsky, member of the Constitutional Council of the Republic of Kazakhstan, Doctor of Law, Professor, who will be providing a speech which is called, the topic is New Constitutional Law is the basis for the construction and evolution of a modern state and a developed civil society in Kazakhstan. I think that it is a very informative title already, that this is a very important topic. We will be really interested to hear more. Mr. Malinovsky, the floor is yours. Thank you very much, dear Mr. Igor, dear colleagues, ladies and gentlemen. In the establishment of any state as a modern, democratic and legal, one of the primary and fundamental positions is assigned to the formation of stable constitutionalism and the establishment of a lasting regime of constitutional legality. The rule of law is, first of all, a constitutional state. In general, the constitutional process in the Republic of Kazakhstan is an example of a very difficult affirmation of real constitutionalism in one of the countries that belongs to the former heirs of the Soviet class traditions. It is due to the peculiarities of the subject of regulations that the principles and norms of the constitutional law permeate the main areas of the life of Kazakhstani society. During the last decade of 20th century, Kazakhstan has practically from scratch prepared and adopted legislative acts in the field of the organization of state power, human rights and freedoms, economic and a number of other groups of relations. The required institutional, organizational and other activities are being carried out. This comprehensive, scientifically grounded, consistent activity of state bodies, the scientific community, and non-state structures, think tanks in their totality constitutes the constitutional and legal policy of the country. the comprehensively balanced and pragmatically reasonable position of the supreme power expressed in the legal policy allowed Kazakhstan to avoid one step forward, two backward disease. Which is typical for most countries intoxicated with independence, liberal rushes, and subsequent conservative kickbacks. Of course, in this, the key role is assigned to the will of the supreme power. Personal direct leadership of the formation and consolidation of the constitutionalism of the first president of the republic, Elbасы Nursultan Nazarbayev, and the constitution of his strategies by the President of the Republic of Kazakhstan, Mr. Tokayev. Indeed, according to the Article 40 of the Constitution, the head of state determines the main directions of the state's domestic and foreign policy. The key components of the constitutional identity of Kazakhstan were determined at the nationwide referendum on August 30, 1995, when the current constitution of the Republic was adopted. It became possible to combine the evolution of positive law with the needs of social progress in Kazakhstan in terms of goals, content, priority, forms, means, and performers through the preparation and implementation of state planning documents. The two strategies for the country's long-term development based on the constitutions of the Republic of Kazakhstan are distinguished by higher methodological, political, ideological, and patriotic saturation. The progressiveness of many initiatives of the head of state, Mr. Tokayev, in particular the concept of hearing state, is embodied in his annual messages to the people of Kazakhstan, as well as in the National Development Plan of the Republic, recently approved by him. The national priorities of Kazakhstan until 2025, the concept for the development of public administration until 2030, the presidential decree on further measures in the field of human rights protection, and other fundamentally significant documents. The President of the Republic also approves the concept of legal policy, which is the basis for the development of long-term and annual plans for legislative work of the government of the Republic of Kazakhstan. So the first President Elbасы approved and implemented the concept of legal policy for 2010-2020, prepared as a successor to the concept of the same name approved in 2002 with a validity period until 2010. In turn, the state program of the legal reform in the Republic of Kazakhstan, decree of the President of the Republic of Kazakhstan on February 12, 1994, and the decree of the National of the Republic of Kazakhstan of June 16, 1993, on measures to increase the efficiency of legal reforms in the Republic of Kazakhstan with the changes introduced by the decree of the President of the Republic of Kazakhstan dated December 12, 1995, based on the new Constitution of the Republic of Kazakhstan adopted on August 13, 1995. In the second half of the 90s, the last century, on the basis of 1995 Constitution, a new constitutional law was created. The concept of legal policy 2002 confirms the following. The constitutional ideas of the rule of law should be embodied in the formation of legislation on the ideas of law, justice, humanism, in the creation of effective means of strengthening the rule of law, material organization, legal political guarantees of rights and freedoms of a person and a citizen. In the second half of the 90s, we've created the new constitutional law. In the concept of legal policy of 2002, it is confirmed the following. The constitutional ideas of the rule of law should be embodied in the formation of legislation on the ideas of law, justice, humanism, in the creation of effective means of strengthening the rule of law, material, organizational, legal, political guarantees of rights and freedoms of a person and of a citizen. We especially note that based on the strategy Kazakhstan 2050, by the decree of the President of the Republic of Kazakhstan dated January 16, 2014, in the concept of legal policy for 2010-2020, a number of changes have been made. is which without the slightest exaggeration has a systemic significance and preservation. The legal policy should be as balanced and pragmatic as possible. If necessary, it should borrow institutions that meet the national interest of the country from the other legal systems, albeit traditionally not typical for the Kazakh one, but which have proven their effectiveness in practice, with a general process on convergence in various legal systems. Taking such borrowings can be useful for the modernization of the national law of the Republic of Kazakhstan. The accelerated pace of development of the state, the widespread introduction of the rule of law, the strengthening of the role of the civil society, the deepening processes of globalizations determine the vector for the formation of constitutional and legal acts of new generation, and for certain laws already of the third and even fourth generation. In the implementation of the latest strategic planning documents, the President of Kazakhstan, Mr. Tokayev, a little over a month ago, approved a conceptual plan of legislative work 2021-2026. Improvement of legislation in the areas of charities envisaged, volunteer activities, development of digitalization and information security, cybersecurity, protection of personal data, and in many other areas. As a key one, we will also cite the following opinion of the President, quote, "It is necessary to study and introduce into the legislation of the Republic of Kazakhstan the best international experience to improve the Kazakhstani legal system in order to increase its competitiveness and investment attractiveness, as well as to create a more favorable environment for doing business." In order to achieve the listed goals, in the course of the innovative, very complex and comprehensive legislative work that has begun, I consider it possible to express 7 conclusions and wishes. First, the objective evolution of Kazakhstani society requires unconditional consideration of the meaning of constitutional values, provisions, and norms of the basic law, both in the adoption and application of laws. The new constitutional law is a primary means and element in the system of current law, bearing constitutional values, semantic, goal setting, and regulating laws. Secondly, the complexity of constitutional matters, the diversity and mobility of relations of constitutional regulation requires special scrupulousness in the use of the constitutional conceptual apparatus. The correctness of the use of these concepts often decisively affect the content and direction of lawmaking, the legal certainty of legal acts, and their subsequent application. Thirdly, a significant role in the constitutionalization of legislation is played by the legal positions of the Constitutional Council, what Mr. Maminov has already mentioned. Fourth, there is an expansion of the subject of constitutional regulation, a redistribution of social relations between constitutional, civil, administrative, and other branches of national law. The utmost care and attention must be exercised here. Fifth, along with the actualization of the constitutional and legal problematics, there is another important act, the intervention of constitutional in other branches of law. Given any branch of the law sphere of legislation a constitutional meaning, content will only strengthen the potential of both constitutional law, constitution, and the corresponding branch in general, and at least stimulates jurists and law enforcement to compare their recommendations, acts, and actions with the basic law more often. Along with the continuation of gradual integration of the legal system of Kazakhstan into supranational international law, the face of known challenges and threats, to protect the sovereignty of young Kazakhstan. And seventh, we have our own constitutional history, and a very indicative one. The experience of constitutional construct accumulated over nearly 30 years, or even more than 30 years of state independence, include a balanced approach to the main law as a goal and means of building a new society, formation of reasonable balance of general recognized and national values, combination of acceptable foreign experience and our own developments, nationality and professionalism, stability and sensitivity, balance and accurate implementation of constitutional and legal policy and other rules, created on the achievements of modern state and its own vision, democratically organized, effective, and constantly improving state power, government embodied in the presidential form, protected country, saved the country from collapse, ensured the passage of Kazakhstan through the most difficult stage of comprehensive modernization in conditions of social harmony and political stability, and led society on the path of sustainable development. The experience of the formation and consolidation of constitutionalism in Kazakhstan in the coordinates of one space, one time, and one social community deserve the most careful attention, application, and research. Thank you very much for your attention. Thank you very much, Mr. Victor, for a very detailed report, for a great speech. Legal experts, which actually were part of time when Constitution was just a collection of very beautiful provisions and very beautiful statements has passed, and Constitution now identifies development of the other branches of legal system, and constitutional norms affect other sectors of law and to the application of law. And this role of constitutional law plays, thanks to from the very beginning of our sovereignty, placed particularly close attention to constitution, to following its norms, and was the guarantor of the constitution, freedoms and rights of the citizens. And now, based on your report, Mr. Victor, we see that constitution and constitutional law is the key and the major thing serving as a basis of our legal system. The next speaker, also as a doctor of law, professor, head of the Akim's office of Almaty, you can see that we have legal specialists in very high positions in the country. His topic is also very interesting. He will tell us about evolution of law in a digital society. I believe that it will be a very important and interesting perspective, in particular for proper understanding of law in modern age. Mr. Talhat, please, the floor is yours. Mr. Igor, thank you very much for this opportunity. Dear colleagues, I would like to congratulate all of you with the upcoming big celebration. And today my speech will be in line with the topic of today's roundtable, and I would like to highlight for myself only a specific part related to the development of law or of the condition which is currently prevailing within our digital community and society. Of course, we are all witnesses of very fast technological progress. It's very evident and colossal. I would like to pull your attention towards the fact that today we are having this event both offline and online. Several years ago, it was something unusual, but today it's a norm. It is a very common thing, and nobody is actually surprised by this mode, having everything online. Today, education, medicine, trade, banking sector, different services, industries, travel, and other experiences, other sectors of our life on an hourly basis are migrating towards digitalization. Its participation there prevails now. Big data, cryptocurrencies, tokens, big data, artificial intelligence, not so long ago, were very rare phrases understood by just very limited amount of people. But today, majority of people live with this terminology, or at least actively uses it in its day-to-day life. It is multi-billion sectors, which covers big amounts of people and funding. We have such understanding as digital space, digital world, cyberspace. It is a integral part of our life today. As you probably remember, Mr. Nazarbayev, in his annual address to the people of Kazakhstan in 2017, said that Kazakhstan, as a part of the global community, cannot stay put. We should also be part of this technological industrial progress. And today we also are involved in this huge international and global process. Today, for many governments and countries, digitalization is a priority for development, and it's not a surprise. Today, leading economies of the world pursue digital development and show high speed of economic development based on the ranking of Harvard Business Review. For 2020, leaders in digitalization and economics were such countries as Singapore, USA, Hong Kong, South Korea, Taiwan, Germany, Israel, United Arab Emirates, Malaysia, and other countries. In the same ranking, Kazakhstan was in the category of prospective countries. With the digitalization of economy due to specific reasons is limited, but this is a country digitalizing on a speedy manner. Today, internationally, there are a lot of smart cities which, thanks to their digital technology, created new urban conditions, improved quality of life thanks to the city informatics, improved public services, and serve the needs of the urban populations. I am telling all of this for us to imagine what kind of global digitalization covers all of us and involves all of us. But still with that, you probably perfectly understand that there are risks and challenges associated with that. And I wanted to discuss that with you. Still within this format, we cannot cover all the problematic aspects and challenges, but just to indicatively touch upon them. When we are speaking about smart cities, first of all, and this practice actually proves that city administrators or the mayor's offices work with private technology firms and companies which collect and process all data about the cities, about citizens of the cities, including all the sectors. Key thing is about the collected data in transport, education, water consumption, crime rates. Also directly linked to the citizens will be stored on gigantic cloud and other servers. There are specific abonnents which actually say that this storages of personal data can be cyber attacked, can be hacked, or data users can actually use this data to discredit that. There might be also the corruption interest, and motives can vary, basically. That handlers of this data cannot be always trusted. The issue is about confidentiality of data collected, and that is a very confusing thing, very worrying thing, and we have to pursue in this direction. It particularly is about protecting the personal data and interests of people. With the technology, we have new problems, new challenges. Today, for example, we have a need to protect our personal data or very new thing such as the right to forget, when parties can require from the search operators to stop providing information about the page owner any longer, which allows to get some data about the specific person. Such a right is actually part of legislation in many countries. It's legalized right. For our law, for our legislation, this issue is in the category of under discussion. Therefore, I believe that in a modern digital age, the key focus should be on our agenda, and it is about protecting interest and personal data of our citizens from open source. We know that Singapore developed in 2019, and basically that was right after Russia, a law on a law about fake news prohibition, protection about POFMA, and put criminal responsibility for dissemination of fake news about persons, about organizations, about society and government. It regulates everything in the internet, not only fake news, but POFMA touches upon different violations about getting involved in voting, and this law provides more details about key definitions. What's very important for us, it puts very specifically what a falsehood is, that it's not about personal opinions, criticism, satire, or sarcasm, or parodies. Digital office has new crimes evolving with the digital technology, and therefore operators should have adequate measures to react to these violations and crimes, and this measure should be reflected in current legislation. For example, in Holland, again, it is from the open source that they developed a draft law about, in case of some offenses made, particularly if it's a terrorist act during the search and during the restraint, they can ask to provide login information for the personal technology items and gadgets. If such access is denied, it is a violation and offense, and every policeman is enabled and requested to report on the search based on the warrant and what measures were taken. Policemen in the United States have different technology to get access to decipher messages and to have access to other digital gadgets. Today, law enforcement bodies, including our legislation actually, is a little bit lagging behind. I analyzed our existing criminal legislation in the Republic of Kazakhstan, and I would like to say that we've done a big step to protect citizens, society in the area of information, informatization and communications. For example, we have a criminal responsibility for improper access to information, for modification or discharge of information, for modification of the information system, or for improper distribution and disclosure of information using different computer programs and so on and so forth. All of that is great, actually. It's a good progress, but still I think that we need legal regulation of such thing as information sharing in electronic format. Actually, we have legislation for the classified information disclosure, but if it is intent-based sharing of classified information is another type of foul play. I believe it should be also protected on the legislation level. It's not, there is no provisions about intent, and therefore it does not cover such items. Moreover, if it is intent-based information provision, there are severe consequences. Therefore, some states have legal punishments for such acts. From open source, we know that the United States and in Germany, information provision is not only a criminal offense, but actually a corruption violation. And I believe this experience can be considered and studied for possibility of implementation. Every person with a gadget has access to internet and is not only information consumer but also information source. There are thousands of people with more than million and 10 millions of subscribers. Some people even have 100 millions of subscribers. Let's just think, the quantity is like a small states and not so small states. Therefore, they are influencers. They are leaders of opinion, and therefore they can start fake news, and consequences can be quite significant. For the sake of example, we can say that cryptocurrency market, which is actively discussed today, and world today is aware of bitcoins, of other playground rules. The price is identified following formulae, and many people invested in that, but still for us it is some kind of not so really and widely researched phenomenon, and is not by any means controlled by the state. The importance here is the absence of fiscal control. United States and other countries are actively researching and studying effect of cryptocurrencies on economics, on different crime rates of on international scale. And this experience, as I believe, should also be practiced here. We should look at this experience and we should take all necessary measures to join our forces, because world today shows that the digital space does not have any borders, and the states separately cannot always adequately respond to different challenges which might be coming up as a result of use of high-end technology. Or, for example, as was with the global financial market, any card holder can actually start an investor. Any statistics today can prove that significant increase of this global market, and that actually is due to the involvement of the private individuals of different social groups. Are clearly some speculations due to some analytic and financial illiteracy, because there are no clear set of rules, and all these acts can expand this bubble. And Of course, we remember all the financial crises, and I don't need to talk in more details about that, about new direction. Today, I believe it's quite relevant to look at the issue of studying and research at the legislation of such issue as national digital sovereignty. Why this issue is raising, because social networks, digital platforms today are tools of political battles or influence on different sectors. Particularly, it's relevant in economic discussions, particularly for corporations in digital sector, legal and individually. They are on the territories of other countries and mainly in the United States jurisdiction, and therefore are not cannot be reached by the jurisdictions of other countries. Of course, this issue should be somehow researched and studied and analyzed, at least on the example of the current situation in China. They are very serious about digital sovereignty. They created unique national digital infrastructure, access to which is quite restricted, or even close to separate digital industries. Due to the limited time, we'll probably stop here. And of course, I would like to thank for this possibility. Separately, another topic is the cyber crimes, and you I think, are well aware of these problems. Just one thing to add on top of that: just several days ago, Elon Musk announced that in September 2020, now internet from his country will cover the whole Earth. What does it mean? It means even in the middle of ocean at a micro island, any person can still be active in global digital space. This is a very solid resource, but at the same time, it is a challenge for the whole planet. Therefore, today I wanted to focus attention that there are different spheres in digital industries which should be today considered by us and should be attracting more attention from us. Thank you very much. Thank you very much, Mr. Talgat. Very great speech. I think it is a very wide topic. Our foundation just not so long ago, together with Sorbonne Kazakhstan Institute, we were speaking about digitalization era, and that it's not upcoming something, that it's something we're already living in. Electronic death, right, that electronic personality is a separate subject. Cryptocurrencies are also considered in the AFC as about creating, if it makes sense, to establish a digital tenge. They are still considering these possibilities, but this is a very interesting topic and it touches upon legal aspects, of course. And just not so long ago, I've read yesterday or day before that our president signed law on regulation of the work of citizens in a distance mode, so working online, and this is one of the outcomes of digitalization. I should probably go back again and again to this topic, and we should keep discussing it. And when we're speaking about the legal system of our country, we should consider digitalization aspect. And now I would like to, Mr. Igor, apologies, just a second. If you're interested, I was citing articles from the criminal code. In 2014, there was a new criminal code approved, different types of violations and offenses described. I looked at the statistics from 2016. In our information system, on this topic, we have 522 offenses, and only 63 cases were sent to the court. And actually, these cases are still considered, and their fate is questionable. We have deficit of experts to look and consider and investigate such cases. And today we are short of any kind of methodology to investigate such crimes and violations. You know, English people have a very good saying that we should not be cursing that it's dark. We should just put some lights on or turn the candle on. Light a candle and it won't be actually dark anymore. And discussions like that, those are the candles we are lighting to resolve different issues, including legal issues. Now I would like to tell you about a very interesting presentation and speech we have today. This speaker was already mentioned by Mr. Kelimbetov. And in his welcoming speech, this is Mr. Michael Blair, QC Chairman of AFC Legal Advisory Council, leading counsel at 3 Verulam buildings in London. And topic of his speech will be AFC law as part of the legal system of the Republic of Kazakhstan. So basically what we already said, that AFC law is already part of the legal system of the Republic of Kazakhstan. Dear Mr. Blair, please, the floor is yours.
Thank you very much indeed, Professor Rogov. I'm delighted to be here to join you in our event dedicated to the 30th anniversary of the independence of Kazakhstan and the 23rd anniversary of the capital city. I'm among honorable guests, distinguished speakers, and indeed friends. And I'm privileged to follow the opening speech of the governor of the AIFC, to which you just referred, Professor Rogov. I hope to be able to add a little more detail about the establishment of the AIFC with its special legal regime in Nur-Sultan, and about the role which the Constitution of the Republic played in the development of this unique financial center in the region. The AIFC is increasingly recognized as an important component of the countrywide economic and institutional reforms aimed to catalyze Kazakhstan's economic progress and inclusive growth by providing an attractive environment for foreign investors. Shall I go on, Mr. Rogov? Yes. A few words first, therefore, about the inspiration of the first president of Kazakhstan. History shows clearly the aims of the first president of the Republic in starting the process for the creation of the AIFC. He saw the AIFC as a response to a new global challenge. Large-scale international and structural reforms are being implemented in Kazakhstan, he wrote. They aim to make the country more competitive and to elevate it to a place among the top 30 developed countries in the world. Those were his words, in Russian, of course. The establishment of the AIFC was one of the major projects in the plan of the nation. The AIFC covers 5 of the 100 steps, which together provide a legal basis, an attractive environment, and a sustainable function for the new financial center. The 100 steps have already been mentioned in the course of this event. Those 5 steps reveal that the first president had 4 aims relating to the project for the AIFC. The first was he wanted a financial center that adopted and upheld the best international standards of financial regulation. Secondly, he wanted a center that was infused with the spirit of the common law, as has already been mentioned. Thirdly, he wished the design of the center to draw inspiration from the international financial centers that had arisen during this century in the Middle East. The governor mentioned 3 of them, and also some older markets further east. Fourthly and lastly, but very significantly, the first president called for a financial center to be of benefit for Kazakhstan as a whole. The result of these 4 aims is stated succinctly in the Constitution of the Republic and in the 2015 Constitutional Statute on the AIFC. So I'd like to turn for a moment to the Constitution and that constitutional statute. The key piece of legislation passed in Kazakhstan was the Constitutional Statute of December 2015, passed by the Parliament of the Republic, signed by the President into law in December 2015. Its enactment took place as part of the implementation of the 100 steps. The Constitution itself was amended in 2017 to enable the AIFC project, and that change to the Constitution was verified as fully in compliance with the Constitution of the Republic of Kazakhstan of 1995. As enshrined by the Constitution, economic development for the benefit of all the nation should be supported by the government. That's Article 1(2) of the Constitution, as you will all know. Under that key requirement, the Constitution was amended first to give a full effect to the fundamental principle of supremacy of the system of existing law in Kazakhstan, and secondly, to ensure the effective functioning of the new AIFC. The Constitution, as the supreme document of the nation, provides a solid foundation for the successful development of the country, acting as the will of the people. I'm quoting there from Article 2 of the Constitution, and the AIFC is an important part of the arrangements in place for that development. The result of all this was to establish a sure constitutional ground for the functioning and further development of the AIFC. It implemented the far-sighted policy of the first president to establish a financial hub in the heart of Eurasia, and this ensured legal certainty and a clear vision for the future of the AIFC from the perspective of the country of Kazakhstan as a whole. Lastly, a few words about the AIFC law as a special part of Kazakhstani law. The AIFC was given a defined legislative capacity, and its system of law depends, according to the constitutional statute, upon its not being inconsistent with the constitutional statute itself. This means that the AIFC legal system is not a sovereign system, but valid only insofar as it does not exceed the bounds for its lawful existence, which are set by the constitutional measures. And as long as no steps are taken to narrow or abolish what is now in place at the constitutional level to define the permissible extent of AIFC law. The law of the AIFC is an innovative and special legal regime, but it is still essentially Kazakhstani in nature. This special legal regime in the financial sphere is based, as has been mentioned already, on the principles, legislation, and precedents of the law of England and Wales and the standards of leading global financial centers. That provides a strong foundation for the success of the AIFC, providing a unique platform and commercial opportunities with a suitable and flexible legal environment, which has proved to be attractive to foreign finance and investment. The codified common law, which is the subject of the book, which the governor mentioned a few minutes ago, was specially written for the center and has been widely welcomed. The judicial system as well, which we'll hear about shortly, is seen as very suitable for the imaginative venture pioneered in Kazakhstan. So my conclusion is the center took its allotted place inside the sovereign state, and since then, the AIFC has continued to operate with the benefit of significant welcome and support and goodwill among the most influential circles in the Republic, some of whom are here present today. You all have very much to be proud of. Thank you for your attention.
Спасибо. Спасибо большое.
Thank you very much. Thank you very much, Mr. Blair, for a very interesting speech. And I would like to congratulate you again with the publication of your book, mentioned by Mr. Kelimbetov. Yesterday we attended presentation of this book. I believe it is of a huge interest both for Kazakhstani legal experts, councils, for financial specialists, for everybody interested in financial and economic activities in the legal system. I should mention, I actually told it yesterday, but I would like to reiterate myself. With Mr. Blair, we together a couple of years ago attended St. Petersburg Legal Forum. And there, Mr. Blair presented Academy of the AFC law and actually talked about the legal system which was established within the AFC. It was a very interesting discussion, which was further evolved as a voting. There was a question: who believes that the convergence is prospective? This convergence between common law and European law, because in Russian Federation and other countries, people are very critical and actually are not very welcoming for such considerations. And after your brilliant presentation, they were very positive, and vote was actually showing that more people are now in support of such convergence. I believe it is a huge propaganda and for real practice for AFC. Thank you very much, Mr. Blair. And now let me continue the AFC topic. It's my great pleasure to provide the floor to the registrar of AFC and AIC to Mr. Christopher Campbell Holt. And topic will be World-Class Common Law Court and International Arbitration Center for Kazakhstan. AFC Court and AIC. Please, Mr. Campbell Holt, the floor is yours.
Professor Rogov, thank you very much for your kind invitation to speak at this very important roundtable event this afternoon in the Sultan Kazakhstan. Before I give my brief remarks on behalf of the AFC Common Law Court and the Independent International Arbitration Centre, the AFC, I would like, if I may, on behalf of our first Chief Justice of the AFC Court, Lord Wolfe, our current Chief Justice, Lord Mance, and the current Chairman of the International Arbitration Centre at the AFC, to warmly congratulate the leadership of Kazakhstan and everyone in Kazakhstan on the occasion of the 30th anniversary of its independence, and secondly, on the occasion of the 23rd anniversary of the Kazakhstan capital city, Nur-Sultan, which, if I may say so, I have had the great privilege to be living in for close to 5 years. The AFC Court and International Arbitration Centre at the AFC are, we believe, as two separate, legally independent institutions within the AIFC, within the Republic of Kazakhstan, are increasingly playing a significant contribution towards not only the formation, but the continued and ongoing development, rapid development, of the legal and judicial systems of the Republic of Kazakhstan. I would say, in my view, the most important contribution that the AFC Court and International Arbitration Centre are already providing to Kazakhstan are the profound international standards an application of independence, impartiality, and above all, incorruptibility, applying the very highest international standards without question of the rule of law. It is not just that this court and arbitration centre are on a daily basis applying these very important principles for Kazakhstan, but that they are seen and increasingly recognised by the international and the regional investment community as doing so. What that does, and what we hope that will continue to do for the forthcoming years, is to build significant trust and confidence with local, regional and international investors that when they invest their money and interests into the Republic of Kazakhstan, that their rights will be protected 100% of the time, without question, with regards to independence, impartiality and incorruptibility. They will, without doubt, receive what a judge, an independent judge or an independent arbitrator or mediator decide fairly and equitably as being the right of the investor in the best interests of justice. Now, the International Court at the AFC is based on the principles of the English and, may I say, the global common law. What we are all familiar with from the English legal system, the world-leading commercial court in London. Well, now we have, for the first time, not only in Kazakhstan, but for the first time throughout the entire Central Asia region, a similar court that is increasingly recognised globally by investors as providing the very highest, most trustworthy standards of justice for the dispute resolution of commercial and investment-related disputes coming to Kazakhstan. The court is headed by its Chief Justice, Lord Mance, the former Deputy President of the United Kingdom Supreme Court. He is supported by 8 world-leading common law specialist, commercial specialist judges who all have, collectively and independently, international experience at the very highest level, not only of common law, but in some instances civil law, across commercial litigation, arbitration, mediation, and other forms of dispute resolution. What this does is immediately send out a very powerful signal from the highest level of the government of Kazakhstan to the rest of the world that Kazakhstan is now fighting and promoting the very highest standards and applying the very highest standards of the international rule of law. Investors should come to Kazakhstan for many reasons, but above and beyond anything else, they can trust Kazakhstan, that when they invest into Kazakhstan, they will receive rightful protection in the compliance with the best international standards. The court applies the very highest international procedural common law standards. It has already attracted considerable attention and support of the international investment community. We are only entering the 3rd quarter of the 4th year of the AFC Court's operations, and yet in that time it has well and truly ahead of schedule, ahead of the level of success, if you like, of other international financial centre common law courts. And in that I include all of the courts of the Middle East, including my old court in Qatar in the Middle East, and indeed the courts in Singapore. It has ahead of time achieved considerable caseload. We have, to today's date, already successfully resolved across our court and our arbitration centre a total of 536 cases, all of those cases being commercial and or investment related. A part of that success has increased the international recognition and support of the investment community. In this key regard, we now know that as a very minimum statistic, the international commercial investment community and local and regional have now including some of the most respected, some of the largest, most important global corporations around the world, have now included both our court and or our arbitration centre into more than 5,000 business contracts. We know through the support of our governor, Dr. Karek Kelenbatov, and the support of the government of Kazakhstan, that there are ongoing discussions with the entire oil and gas sector of Kazakhstan, who are increasingly looking with support to include our court and arbitration centre in some very high value, important commercial contracts. We expect the success of the court in terms of its user function, its caseload, and its recognition internationally to significantly increase in the coming years. The International Arbitration Centre is chaired by our chairman, Barbara Doman QC. She is a very highly respected at the international level commercial litigator, arbitrator, and mediator. And with her, we have an independent, highly expert panel of arbitrators and mediators, comprising some of the most renowned and most respected arbitrators and mediators from within Kazakhstan, from within the wider Central Asia region, and critically, for the success of the AFC project and our arbitration centre, from the global arbitrator and mediator community. We are fortunate to have attracted the trust and the support on an ongoing basis with our arbitration and mediation cases of the most respected, the most qualified experts from around the world. Our arbitration centre has alone resolved more than 511 disputes across arbitration and mediation. We have, across the Court and Arbitration Centre, successfully resolved to completion more than 200 cases. Again, we are only in the second half, just entering the second half of our fourth year of operations. I expect the success to continue for the forthcoming years and months. Where does this take us? Well, this takes the AIFC and Kazakhstan, in my view, to a completely different level at international recognition. This really assists with what Mr. Blair QC and the governor of the AFC and other distinguished members of this panel have already said today. It takes Kazakhstan to a completely different level of possibilities. Possibilities of investment, of respect, of trust, of recognition around the world. For investment primarily as a safe place to come and invest your money if you are an international investor. But it also has other related benefits, both within Kazakhstan and outside of Kazakhstan, but for the benefit of Kazakhstan and its people. One or two of those I'll touch upon now, if I may, very quickly. When we built the court and arbitration centre at the AFC, and indeed the legal system of the AFC in Kazakhstan, we were always minded to work in the closest cooperation, independently, as we must do to secure the trust and confidence of the international investment community to invest into Kazakhstan. But critically, we have, and we continue to do so, cooperate at the highest level of government of Kazakhstan and with its most important and recognised institutions. With regards to what I do and what our judges and arbitrators do at our Court and Arbitration Centre at the AFC, that has included close, independent but close cooperation, in particular with the Chief Justice, Chairman Jakub Asanov, and Chairman Mami from the Constitutional Council, and our friends at the Constitutional Council, for some years to share perspectives, to bring this international experience and approach, not just to Kazakhstan, but with Kazakhstan, to establish a truly special, independent, internationally regarded dispute resolution and legal system through the AFC for Kazakhstan, building upon the very best of the traditions of Kazakhstan, but bringing also the best international experience and recognition to bring the two together to provide a truly special system of law and dispute resolution for Kazakhstan, which I truly believe will continue to gain that international respect, trust, and proven results with increased investment for Kazakhstan. Thank you very much.
Thank you very much, Mr. Campbell-Holt, for your very interesting speech. I just wanted to add a couple of words to the information you've shared. A very big interest is placed both to the AFC court and also to AIC, not only from international investors, but also from Kazakhstani business. In particular, that the Civil Procedural Code of the Republic of Kazakhstan was amended not so long ago, and now it allows to go and to make a claim to international court to AFC court and AIC, and the interest is actually huge. The practicing legal counsels approached us asking to have some kind of a webinar or some kind of a training, but most likely a webinar together with AFC for our foundation to organize something in partnership with you. And also with the Sorbonne Kazakhstan Institute. And actually the director, today we can see her among our participants. She is currently on the screen. And the next, I would like to provide the floor to her, but she asked to go next and to for her French colleague to go first. Former judge of the Administrative Court of the French Republic, Doctor of Laws, professor at the University of Strasbourg, France, to Professor Patrick Dolat, but our colleagues informed me that there are some technical issues and hiccup. There is no video, but if he can hear you, Mr. Dolat, if you can hear us and you can turn your microphone on, then we can provide the speech to you, even without video, though it's not very convenient, but he has very interesting topic, the Constitution of the Republic of Kazakhstan, identity, democracy, and rule of law. Such an outsider perspective. Let's give it a try. Mr. Patrick Dolat, the floor is yours, please.
Could you hear me? Good morning.
Слышим, мы вас не видим, но
Yes, we can hear you. We cannot see you, but we can hear you, and we can proceed. Please, the floor is yours. We can hear you, but we cannot see you. Can you hear me? Hello? Hello? Can you hear me?
Your speech, please. Okay.
Yes, but in fact, I tried to be connected, but nobody can hear me. And I thought that you try to call me with WhatsApp. I'm speaking, but it doesn't work. Nothing is working.
слышно, вас слышно.
We can hear you. Patrick, we can hear you. There is no video, but we can hear you. And with a great pleasure, we are ready to attend to your speech. And if we are lucky enough, probably we will be able to see you today. Can you go ahead, please, with your speech? Dr. Patrick, the floor is yours.
Can you hear me? Yes, you can hear me.
Yes, we can hear you.
Thank you very much, Mr. Shannon. And I sincerely thank you for this invitation to the anniversary of the independence of Kazakhstan and to the anniversary of its capital. It's very great. And my contribution will focus on the Constitution of Kazakhstan, identity, democracy, and rule of law. Through a legal approach, how may it be possible to conciliate the respect of the Kazakh identity, the democracy, and the rule of law? That is one of the key purposes of the Constitution, adopted in 1995, revised in 2007 and 2019. Thus, from the first line, the preamble of the Constitution of Kazakhstan clearly affirms the will to protect the Kazakh identity, historically, geographically, and morally speaking. I quote, "We, the people of Kazakhstan, united by a common historical fate, creating a state on the indigenous Kazakh and considering ourselves a peace-loving and civil society, committed to the ideals of freedom, equality, and concord. In addition, considering democracy and the rule of law, the first article specifies the Republic of Kazakhstan proclaims itself as democratic, secular, legal, and social state whose highest values are person, his life, rights, and freedom. Strictly speaking, the expression rule of law is not used. However, the concept of a legal state seems to be preferred language used in the Kazakh constitution, if my translation is absolutely right. Thus, the purpose of this contribution consists of scrutinizing how the constitution protects the Kazakh identity in creating a state on historic Kazakh land. First, in addition, how it guarantees the fundamental principles of a modern state, referring to the respect of the rule of law and democratic principles. First, the protection of the Kazakh identity must guarantee the creation of a state on historic Kazakh land. According to Article 2 of the Constitution, as amended in 2019, the name of the capital of Kazakhstan is referred to as the city of Nur-Sultan. However, Article 9 does not clarify the meaning of its state symbol, I mean the flag, emblem, and the anthem, but a separate constitutional law establish their description and order of official use. Nevertheless, there are two original and key elements that are needed to protect the Kazakh identity. Kazakhstani patriotism as a fundamental principle of the Republic, point 1.1, and Kazakhstani citizenship as an exclusive citizenship, point 1.2. 1.1, Kazakhstani patriotism, a fundamental principle. As with many foreign constitutions, the general provision and first articles of the constitution are devoted to protect the Kazakh identity and specifying its meaning. Using Article 1 as a reference, which states Kazakhstani patriotism as a fundamental principle of the activity of the Republic, Article 2 logically indicates that the sovereignty of the Republic shall cover the whole of its territory. Thus, Article 5.4 prohibits activity of political parties and trade unions of other states, religious parties, as well as the financing of political parties and trade unions of foreign legal entities and citizens. Moreover, point 5 indicates that activities of foreign religious association, as well as the appointment of head of religious association by foreign religious centers, should be carried out in coordination with the respective state institution of the Republic. Second element, Kazakhstani citizenship is an exclusive citizenship. Concerning the citizen of Kazakhstan, Article 7, points 1 and 2 distinguish Kazakh and the state language, distinguish Kazakh as a state language and the Russian language as an official one. Nevertheless, the Russian language should be officially used on equal grounds along with the Kazakh language in state institution and local self-administrative body. Finally, point 3 obliges the Kazakh state to promote conditions for the study and development of the languages of the people of Kazakhstan. However, this statement perhaps could be ambiguous because of the numerous minorities living in Kazakhstan with Kazakhstani citizenship, including Koreans, Kyrgyz, Tatars, Germans, not to mention the desired practice and learning of the English language. Moreover, Article 10 in Section 2 title Person and Citizen clearly states that a Kazakhstani citizen shall not be deprived of citizenship, but has the right to change such citizenship. It may not be expelled from Kazakhstan, but deprivation of citizenship may be allowed by a court decision for the commission of terrorist crimes, as well as for causing other serious harm to the vital interest of the Republic of Kazakhstan. Such a deprivation is not in accordance with the convention related to the status of stateless persons, but the Republic of Kazakhstan did not sign this international treaty approved in 1954. Finally, differing from the Constitution of the Russian Federation, in which its own Article 62.1 recognized dual citizenship, Article 10.3 rejects such a dual citizenship in Kazakhstan. I quote, "Foreign citizenship of a citizen of the Republic shall not be recognized." Historical reasons clearly explain this position. After the independence and the collapse of the Soviet Union, Kazakhstans represent a minority of the population within the Kazakh territory, but Russians a majority. Thus, each person living in Kazakhstan had to declare their exclusive citizenship in order to affirm the idea of Kazakhstani patriotism. The Constitution of the Republic of Kazakhstan protects the Kazakh identity, but the Constitution of the Republic of Kazakhstan respects the democracy and the rule of law as the fundamental principle of a modern state. First of all, how the rule of law and democracy can be distinguished. The rule of law is a legal concept, is defined by the recognition of fundamental rights which must be protected by the state, and if the judge finds that the state itself has failed in this obligation, it may be condemned by the court and will have to repair the damages caused by its violation. For its part, democracy is a political concept relating to the legitimacy of power and the acceptance by citizens of the constraint that a political regime can impose. It's generally understood as the government of the people, by the people, and for the people. Democracy is based on the principle of the separation of power adopted by the people. The law is the expression of the general will, and its respect is controlled by the judge and the citizens. Although distinct, these concepts are closely linked in terms of their implementation and preservation. Authoritarian regimes do not adapt well to the protection of fundamental rights, which they drastically limit under the pretext to defend the interest of the state, when these interests have in fact only served the benefits, those of dominant social group. In addition, the guarantee of freedom of expression, information, association, or demonstration are the essential corollaries of the citizens' right to vote, so that they may keep themselves fully informed and civically involved. Considering the text of its constitution, the Republic of Kazakhstan recognizes democratic principle, point 2.1, and must respect the rule of law with the protection of the fundamental rights, 2.2. 2.1, the recognition of democratic principles by the Constitution of the Republic of Kazakhstan. In the first three articles, the Republic of Kazakhstan proclaims itself as a democratic country with a presidential form of government. The people shall be the only source of governmental power. They shall exercise power directly through national referendums and free elections, and delegate the execution of their ability to state institutions. Thereby, the citizens shall have the right to elect and be elected to public and local self-administration, as well as have an equal right to serve in public administration, Article 33. However, the formation of political parties in state bodies shall not be permitted, Article 5. Consequently, the President of the Republic of Kazakhstan is elected by adult citizens of the Republic based on equal, universal, and direct suffrage. Article 41. The Parliament consists of two chambers, the Senate and the Majlis, elected for 6 and 5 years. Article 50. Finally, the government is formed by the President. Article 65. Within its activity, the government is accountable to both the President and Parliament. Article 64, and it must resign its power to the newly elected Majlis by the Parliament of the Republic. Lastly, the Maslihat, if my pronunciation is right, as local representative bodies, must express the will of the population and of the representative administrative territorial units in the respect of national interests. They are elected by the population based on equal, universal, and direct suffrage by a secret ballot of terms of 5 years. Last but not least, the Constitution of the Republic of Kazakhstan guarantees the respect of the rule of law with the protection of the fundamental rights. The Kazakh Constitution must have the highest judicial force and direct effect on the entire territory of the Republic, Article 4. And according to Article 12, human rights and freedom shall be recognized and guaranteed in accordance with this Constitution. Thus, everyone shall have the right to legal defense on their rights and freedom, and legal assistance must be provided free of charge, Article 13. These rights are detailed from Article 15 to 33 and focused on the right to live, personal freedom, inviolability of private life with the protection of honor and dignity, freedom of speech and creative activities with the prohibition of censorship, freedom of forming association except for military servants, employees of national security agency and judges, freedom of labor, protection of property and health, the right to obtain higher education and to assemble peacefully, to hold meetings, campaigns, and demonstrations. Nevertheless, all citizens bear responsibility owing to his citizenship, Article 12, and the exercise of citizens' human rights and freedoms must not violate the rights and freedoms of the people nor infringe on the constitutional system and public morals. Thus, everyone must observe the Constitution and Kazakh legislation, pay legally established taxes, undergo military service, take care of historical heritage and nature. However, restriction of the rights and freedom of citizens for political reasons shall not be allowed in any form. Last but not least, according to Section 6, titled Constitutional Council, Articles 71 to 74, and Section 7, titled Courts and Justice, Articles 75 to 83, The constitutional control and judicial power have to ensure the protection of the rights, freedoms, and legitimate interests of citizens and organizations, and the enforcement of the constitution, law, regulation, and international treaties. Article 76. Therefore, the judge must be independent and impartial. Everyone has the right to be heard in court, and indeed, any doubts about the culpability of the accused shall be interpreted in their favor. Article 77. Thus, amid the economic and environmental and social crises, some governments contest the efficiency of democracy based on citizenship and human rights because they are not confident in their own people. However, Winston Churchill declared on November 1947, many forms of government have been tried and will be tried in the world of sin and war. No one pretends that democracy is perfect or all-wise. Indeed, it has been said that democracy is the worst form of government, excepted for all those other forms that have been tried from time to time. The Republic of Kazakhstan is a great country with a very well-educated young people who are traveling and studying abroad. This country, Kazakhstan, can be an example in Asia, reconciling respect of its identity, of the Kazakh identity as an open country with a modern conception of the state based on democracy and the rule of law. I sincerely thank you for your attention. Thank you.
Thank you very much, Dr. Dolat. Actually, I'm really inspired by the depths you studied how you studied our constitution, and such an outsider perspective is of a huge interest about your perception of our constitution. It is really interesting to us. You touched upon several issues, and I think they deserve a separate roundtable, a separate forum, or even a conference. Even the balance between the rule of law and the legal state. So yes, basically in our constitution we decided to use legal state instead of rule of law. I'm not sure whether it is influence from the German Federal Republic, and probably it makes sense to have some discussions among legal experts, policy researchers on how these two terms relate to each other. But legal state also is in the lawmaking, is in judicial system, and is also applied by our government authorities. If I understood correctly, your disagreement with the third point of the first article about the citizen, about dual, about the about the citizenship, that it cannot be cancelled, but only in case of territorial, not only in case of the terrorism. And yes, if we refer to these other crimes, to this tax, to tax that deprivation can be for causing other serious harm to the vital interests of the Republic of Kazakhstan. Actually, we took this wording, this exact wording from the convention you were referring to. And the Venice Convention, we actually discussed that quite profoundly. And we were not criticized by European experts on this texting and wording. So basically, I said already that all of that has to be processed again and time and again. We have to go back to this definitions: rule of law, legal state. We have Mr. Malinovsky, the member of the Constitutional Council of the Republic of Kazakhstan. If we look at such dispute, or if we have a conference dedicated to this topic, or probably at some point it will be also in the interpretation of constitution in normative level, and at the normative level to fix these principles on how legal state is aligned with the rule of law, and how two principles are interlinked. Essentially said that rule of law, it's not only about the rule of law, as sometimes it is used in scientific and non-scientific discussions. I think we still have room for improvement here, and thank you so much for indicating that in your speech, that it was actually good food for thought, particularly in the eve of the upcoming anniversary of our Constitution this August. Thank you very much, Dr. Dalat. I hope that next time we will be able not only to hear you, but actually to see you. And I hope not only on the screen, but we will be able to see each other offline. We would be really glad to see you here in Kazakhstan. And now is a concluding speech. I mean, it is not something as a summarizing speech, but being a really Kazakh woman. It is, like a well-known tradition that hostess will be the last person to speak, thanking the guests. And Sorbonne Kazakhstan Institute, Ms. Sabitova is the director of Sorbonne Kazakhstan Institute, Doctor of Law, professor. Her topic is Kazakh-French cooperation in the legal field. Mr. Dolat was assumed to be continuing your thought, but now we have the reverse order. Ms. Ainur, please, the floor is yours. Can you hear me? Yes. Good afternoon, dear participants of the roundtable. It is a great pleasure for me to be given speech at such a high-level platform. I would like also to thank organizers. We appreciate your help. Also, our appreciation to the technical support team. And I would like to thank Mr. Rogov in particular. After the Republic of Kazakhstan gained independence, many problems arose before the new state. Establishing strong foreign policy ties has become a priority task for our country, and all the forces of young Kazakhstani diplomacy were directed to resolve it. During the first few years of independence, Kazakhstan was recognized as a sovereign state. Can you hear me? Yes, we can hear you. Thus, the Republic of Kazakhstan quickly and firmly entered the global community from the very beginning. And let me just briefly tell the history of our cooperation. Kazakhstan understood that the foreign policy should have a multi-vector character. It was on the basis of this principle that the foreign policy concept Kazakhstan began to form. From the very beginning of the formation of the foreign policy of sovereign Kazakhstan, great importance is attached to the European vector. This is due to the high degree of economic and political integration in the region. This is due to the key partner of Kazakhstan in Europe were initially Great Britain, Germany, and France. France, being one of the world's political and economic leaders, is of interest to many states. And the Republic of Kazakhstan, of course, was no exception. A relatively young state, which for the period of its formation as an independent state needed to study and somewhere in borrowing and adoption of the positive experience of development as a legal democratic state. It should be also noted that for France, Kazakhstan is a state with powerful potential and great opportunities. The starting point of cooperation between the two countries was France's recognition of the independence of Kazakhstan, which happened on January of 1992. This was followed by the establishment of diplomatic relations on January of the same year. And in March, the French embassy in Kazakhstan was opened, and in July, the Embassy of Republic of Kazakhstan in France. The most important stage in the development of bilateral relations was the official visit of the first president of the Republic of Kazakhstan, Mr. Nazarbayev, to France. It was in September 1992. This visit is significant in that it became the first meeting of the leaders of two sovereign states, Mr. Nursultan Nazarbayev and the French president, Mr. Mitterrand, as well as the signing of the fundamental documents, the Treaty of Friendship, Mutual Understanding, and cooperation, which determines the basic principles of bilateral relations in all areas. Thus, the first official visit gave impetus to the practical implementation of bilateral cooperation. The signed agreement laid a solid legal foundation for relations between Kazakhstan and France, which covers almost all aspects of cooperation in various fields. I will not stop in details on the text of this treaty, but I would like to mention that this treaty states that in mutual relations, both parties act as equal sovereign states on the basis of friendship, mutual trust. And also in this treaty, there is a provision that, if necessary, parties can conclude other treaties and agreements to implement the provisions of this treaty. With Kazakhstan and France carry out political cooperation both at the bilateral and multilateral level. They recognize the universal principles of freedom and democracy and cooperate in the field of protection and promotion of human rights and fundamental freedoms, in particular the relevant international organizations, as well as combining their efforts to ensure international security, the prevention of conflicts, and to ensure the effectiveness of international law. I would like also to mention that in 1992, the President of France, François Mitterrand, paid a return official visit to Kazakhstan. And I would also think that it's worth of mentioning that later Elbasy will make a whole series of official visits to France, and a number of documents were signed during these visits. And I'm already running short of time. What's the problem? Why is the screen frozen? We cannot hear you. Probably some kind of a technical hiccup. So are we running out of time? I'm sorry. Dear colleagues, as I was informed just now by our colleagues responsible for the technical part, internet was disconnected in Almaty. There were some kind of connections. Let's wait for another minute, and if nobody joins in, then we will probably finalize our work today. Okay. Then I think information would be quite interesting, as I assume. Significance of Kazakhstan-French cooperation in legal sector cannot be overestimated, at least due to the fact that our constitutions are very much alike, and French experts were also participating in assisting us in drafting our major law. Roland Dumas, chairperson of the Constitutional Council of Jacques Attali, very well-known political activist, and such institutional council and other institutions and aspects. I think we can get more detailed information later, and we will be publishing it. I would like to apologize for this technical problem. And if you allow me, that will be the conclusion of our work. Let me conclude with that. I would like to thank our co-organizers from the bottom of my heart. This is AIFC, Sorbonne Kazakhstan Institute, all the government authorities which assisted us. In particular, this is the Constitutional Council of the Republic of Kazakhstan, Ministry of Justice. You've seen the top management during the welcoming part. I would like to thank all our speakers for sharing their opinion. Mr. Malinovsky, Mr. Sarsimbaev, Mr. Blair, Mr. Campbell Holt, Ms. Dr. Dolat, and Ms. Sabitova. Apologies for such technical hiccup. We don't know where this disconnection has happened and what is the reason behind this hiccup. But this is still technology. Digitalization is still an ongoing process. It was not concluded yet. Our government and non-government authorities are still working to achieve progress on that. I would like to thank our colleagues who organized this whole event, the technical assistance. Again, initially there were some technical problems due to some problems, probably because this is a new building. There are some things to improve. I would also love to thank the interpreters who provided very high quality interpretation, and we were very much able to understand each other, even though we were speaking different languages. I would love, together with this thank you words, I would like to congratulate all our friends, all our guests, all citizens of Kazakhstan with the huge upcoming celebration with the days of our capital. Capital is is probably the youngest in the world, but still it got international recognition and good reputation. I would like to wish you good health, stay safe, and stay positive. Thank you.